You can think of commercial litigation as it's not just a business dispute, but it can include business disputes. I like to describe it as any litigation that doesn't involve personal injury. So if you have a property dispute, if you have a contract dispute, it can include patents, trademarks, copyrights, legal malpractice. If your lawyer screwed something up that they shouldn't have screwed up, that can be a commercial litigation. The classic example of a trade secret is the Coca-Cola formula. It's a secret formula that somebody can't take a can of Coke and reverse engineer, or basically take it apart and determine how it's made, the secret formula. It's kept secret, and that's a trade secret. But trade secrets are broader than that, and it differs a little bit from state to state, but I practice all over the country, and in general, all the states' laws say if you have something that gives you a competitive advantage, and you keep it a secret, and you're able to keep it a secret, and you require your employees not to disclose it, it's a trade secret. These can include things like customer lists, what customers want to buy, your price lists. All of those types of things can be protectable trade secrets as long as you've kept them as trade secrets and you don't disclose them publicly. Typically, in trade secret cases, there's two types of situations. One is I have an unfaithful employee who used to work for me and left and went to work for one of my competitors. And they took with them customer lists, sales lists, their laptop, their phone, which has all the contact information for all of the customers that they learned while they were working for me. The second type of situation is, and this happens more than people think, a big company will come and visit with a small company under the pretense of some business relationship. And they'll sign a non-disclosure, and they'll talk, and they'll exchange information, and at the end of the day, the big company says, we're not interested. And lo and behold, 3, 4, 5 months later, they start doing exactly what you were doing and what you disclosed to them. So a patent covers an invention, something that you invent, like an improvement on something, and you have to file your patent application now in the United States before you have any commercial activity. So you file an application, it usually takes a year or two, and you get a patent attorney to help you. And then the government, if they think your invention is patentable, gives you a patent. That patent gives you the right to stop anybody else from making, using, selling, or importing your invention in the United States for 20 years. A trademark is a symbol or a name or a color scheme like John Deere green, where customers recognize the name, like Ford, Coca-Cola. Those are all trademarks. And if you do business and you have a name that you do business under, it's usually a trademark. And as soon as you start doing business under that mark, you have rights, you have trademark rights. Copyrights are if you create something. You create a video, you write a song, you write a poem, you write a letter, you take a picture. Those are all protectable copyrights. And as soon as you create that, as long as it's original and it's creative, you own a copyright on it. Again, you can register it with the government, but if anybody copies that, then you have a right to stop that because you own the copyright in it. Another area is legal malpractice, and a lot of people don't recognize that. Say you hire a patent attorney, and the patent attorney didn't file your application on time, and now you can't get a patent anymore. That's a mistake that the lawyer made, and they have insurance for that, and you should be made whole, and they should take care of that for you. If they don't, you have a right to sue them. It's just like medical malpractice where a doctor makes a mistake. Legal malpractice is where a lawyer makes a mistake, and you can sue the lawyer if they don't make it right. Anytime you think that your business is being impacted by a competitor, by an unfaithful employee, somebody that breached a non-compete agreement that left your business, an ex-employee who took some of your information, your trade secret information. Anytime your business is being impacted in a way that you think is unfair, you ought to call me. Because what I can do is sit down with you and say, okay, here's what your rights are, and here are your options. Even if you don't know if you have a case, if you just think that something's going on, you want to get some advice on and determine whether or not you have a case, you don't have to know that you have a case to come to me. If you think you have a problem, call me, and I can tell you whether or not we can help you and whether or not you have a potential claim.